All right. Let me deal with, do I have Mr. Landau? Mr. Landau? All right, this is case number 21-34003, strike that 0063. Granada Apartments North versus Darrell Grant and other occupants of property 15050 Greenfield, number 17. Your appearance on that matter, sir.
Sorry, Your Honor. I'm here.
Right, yeah, your appearance regarding the Granada versus Grant matter, sir.
Mark Lander for the plaintiff, P42790.
Thank you, counsel. And it appears that this is the first hearing date regarding this matter. I have received the proof of service and know the nature of the same. Do I have Mr. Grant on this Zoom? Looks like I do. All right, Good afternoon. Good afternoon to you, Mr. Grant. Mr. Grant, have you had an opportunity to speak with a lawyer regarding this matter?
I haven't had a chance to speak with one regarding this matter.
All right, so I'm going to set it up where you can talk to someone now that will be able to give you some advice and insight regarding this matter. Under the laws of the state of Michigan now, I'm going to set this matter over for a second hearing. It looks like just 1 second. Yeah, it looks like this is a complaint for non-payment of rent. So Mr. Santorio is going to speak with you in a breakout room. But before doing that, I am going to set a new date regarding this matter. And that new date is going to be the 24th of March of 2021 at 9:30 a.m. March 24th, 2021 at 9:30 a.m. That's the next action date in this matter. So note that date, sir. Then I'm going to send you now to breakout room number 1 to talk with Mr. Santorio.
Your Honor, is there any chance I could move it to March 19? I'm not available on the 24th.
I'll go ahead and set it for the 19th. We're going to change that date, sir, Mr. Grant. That date is going to be the 19th at 9:30.
Yes, Your Honor.
Did you hear me, Mr. Grant? The 19th of March at 9:30.
Yes, Your Honor.
All right, gotcha. So there's the notification for you to go to breakout room number 1. Am I sending Ms. Butler there as well?
Yes, Your Honor, and I believe Angelica Scott.
All right.
Do I join now?
Yeah, you can click on to the notification for breakout room 1. You got that, sir?
Thank you, Your Honor. That's all I've got this afternoon. Have a good day.
And likewise to you, sir. All right. Mr. Dyer, are you there, sir? This is case number 21-34073, William Young versus Cassandra Vale and Eric Rolling and other occupants of property at Wickham, 9221 Wickham Council.
Good afternoon, Your Honor. For the record, Coleman Potts, P7A607. I'm getting feedback here. On behalf of plaintiff.
All right, thank you, counsel. And this is the first hearing regarding this matter. And so I will be setting a new date pursuant to the administrative order. I need to know if I have Cassandra Vale or Eric Rolling on this Zoom. Please say something if you're on this Zoom at this time. It does appear that the defendant has not appeared regarding this matter. I will set the matter over then for the 1st of March, 3/1/21, and that's going to be at 9:45 a.m. That would be the next hearing date. If the defendant does not appear on that date, the court will entertain a motion for entry of default judgment, counsel.
Thank you, Your Honor.
Thank you, sir. Good day to you. This is case number 21-340069. This is Detroit Corp LLC versus J. Coleman and other occupants of property at 4800 Corbeil in the city of Detroit. The matter is before the court for a first hearing on a complaint to recover possession of property. Your appearance at this council.
Good afternoon, Your Honor. Alan Dyer, appearing on behalf of the P54857.
All right, thank you, counsel. And I do see Jay Coleman on this Zoom. Good afternoon to you.
Good afternoon to you too, sir.
You live at the property in Corbeil, is that correct?
Correct.
All right, so this is the first hearing in this matter. I am going to set it for a new hearing date. Mr. Dyer, is your client interested in any CR EDP type program?
My client has expressed a willingness to participate. Yes.
Right. So I'm going to go ahead and set the matter on for the, I'm setting the 24th. I could move it sooner, but around that time is when we expect that we'll have sufficient information on this program. Does that date work for you, counsel?
Yeah, I'm not going to object to that, Judge. Thank you.
So 3/24/21, Ms. Coleman is going to be the new date on this at 9:45 a.m. That's when you'll Zoom back in to see me. I'm going to set it up now so that you can speak with a lawyer that can go over your rights and discuss possible resolutions in this case. So just hold tight for a moment. As soon as I have a lawyer back in the courtroom, I'll give you someone to talk to see if you can get that resolved. You understand that?
Yeah.
All right, so just hold tight, Ms. Coleman. All right, the court now calls, do I have Mr. Bajami on this matter, on this Zoom, Mr. Bajami?
He said he was going to be a little late.
All right, not a problem. Do I have Mr. Cox, are you there somewhere, sir? Very well. All right, the court is on the record in case number 20-346587. This is Ashley Master Tenant LLC versus Timothy Kramer and other occupants of property located at 1538 Center Street, number 402 in the city of Detroit. Your appearance at this time, Madam Counsel.
Good afternoon, Carolyn Cohen, P4939.
All right, good afternoon to you. And your name for the record, sir?
Timothy Kramer, defendant pro se.
All right, thank you, Mr. Kramer. Just one moment, sir.
And Judge, I can't hear Mr. Kramer.
Yeah, I'm trying to set that up a little bit better now. All right, so Mr. Kramer, you are going to have to keep your voice up. I do have the other recording device on. Say your name again for the record, sir.
It's Timothy Kramer, defendant pro se.
All right, thank you, Mr. Kramer. The last time we were together, I indicated that an order should be drafted with a proposed resolution of this case. I did receive a copy of the order. It appeared to me that the only thing that was missing in the order was a dissolution of the previous case that was entered against Mr. Kramer, such that there would be a provision that would allow for that order to be set aside so that the defendant can go forward in his pursuit of a new residence. That seemed to have been the only thing missing in the order. Ms. Cohen?
Yeah, I thought I had put that in, and if you look at, first of all, I apologize, I have the wrong case number on that case. I put the previous one, I apologize for that. But plaintiff agrees to a status, I thought, okay, so plaintiff agrees to satisfaction of judgment.
Chuck, you're breaking up a little bit. I don't know whether that's in the system or whatever, but you're kind of going in and out. So if you can adjust any volume or anything on your end, Ms. Cohen, and let's try again. Let's start again. I know that you said you already gave your apologies with respect to the fact that you used the previous case number in this matter, and that's something that's an easy fix. And you were talking about
And then what it should have said is that plaintiff agrees. Number one, plaintiff agrees to a satisfaction of judgment in case number LT 20341268.
Okay.
Yeah, okay, that's what it should have said. That would have taken care of. If you want me to word it differently, other than a satisfaction of judgment, you want me to? I just put satisfaction of judgment. I thought that took care of it.
Yeah, that actually would take care of it, and the court would take action to make sure that is enforced properly. All right, Mr. Kramer, you received a report, sir?
Yes.
All right, what's going on, sir? Talk to me.
Well, first off, I did read her stipulation, and to me, it seems very vague. First off, even the stipulation of the previous satisfaction judgment.
Hold on one second. Keep your voice up.
Sorry, Your Honor. It's vague as to when that satisfaction is going to be applied. Does it start literally from the date that we sign it, or does it address it, like, does it grandfather it in?
Well, let me stop you. Let me stop you on that part and answer that part. What will happen if that order is entered, then this court will take action to set aside the judgment in the other case so that you don't have that as noted as an issue. That's what will happen in that case.
Okay. And secondly, the totals that are listed there don't reflect the market value, the situation that I've lived through in that sort of temporary environment.
And let me stop you there. We talked about that already. If you are going, that's not a subject of a case that's here. What happens is this is a case that involves pay or move. And so the plaintiff makes the allegation that a certain amount of rent has accrued for purposes of an EDP program. If you're able to get some funds and you agree to cooperate with that, whatever funds you get, those would be funds that you would agree to be paid to the plaintiff. Those funds are not going to be $12,000. I think everybody know that. If they think that you owe something more than that, they would have to file a separate lawsuit to collect a judgment against you, because this is not a money judgment against you in any kind of way. This is an order that will dismiss the case.
So long as I put my signature to a document that hits the taxpayers in the state of Michigan for a debt that I don't believe was incurred.
And what you don't have is you don't have a tribal issue on that. That's the issue that you have. You don't have a tribal issue on that. What you have is you have a situation, if somebody sues you for that actual amount of money, then you can raise every issue that you want to raise if they sue you for that money. This doesn't have anything to do with a judgment against you for that amount of money. It has to do with you pursuing EDP and letting the state decide under the special circumstances program of what amount of that money they might be willing to pay. That's what your part is. If the plaintiff then decides that they think that they should get more money, they have to file a separate lawsuit and bring that lawsuit against you saying that you owe X amount of money. And if they do that, that is the case in which you bring your defenses and say, I shouldn't owe that money because of these reasons. The reason that we're talking about this order that's been drafted is because of the fact that no matter what issues you would bring in the context of a hearing in front of me, there's no way that you're going to stay somewhere where the rent emerges to be somewhere like $12,000. If I decide that should be cut in half, you still would owe half. I decided it's cut by a quarter, you still would owe a quarter. So where you are now is you let the state decide what portion they're going to pay. They're not going to pay $12,000. They're likely going to pay somewhere in the neighborhood of $3,000-$4,000, if that much. And if the plaintiff accepts that and then decides that they want to sue you for something more, then you would raise every defense or every issue that you want to raise in the context of them trying to collect something more than what the state paid. The state was willing to pay.
But my understanding is if I sign that stip or order, then I'm essentially validating the value of the apartment, because this is not a traditional holdover situation. I believe it's a coercive situation where I was forced to stay there because of the previous conditions.
Well, your force to stay there is not likely to get you much traction. But to get to your central issue is whether or not you have you acquiesce to owing a certain amount of money. You don't. This document is a document signed in anticipation of a dismissal of this case, a removal of a hindrance to your pursuing your next objectives, and your agreement that you will allow EDP consideration. You'll cooperate with that and let the state look at this and decide how much of that they're willing to pay.
So will the state contact me, or
They have to. You have to put paperwork in for it. You have to apply for it.
have to acknowledge a full amount that this phone is listed there?
You make an application for it. When you make an application for it, you would simply put down, this is what they're claiming. You didn't even tell them, I don't believe I owe that much. This is what they're claiming. The fact of the matter is that whatever, if they release any money to be paid, it's not going to be anywhere near. There's not going to be anywhere near.
No, I do understand that.
It's not going to be anywhere near half of that amount.
I understand.
Nowhere near half of that amount. And if they release something that's nowhere near half of that amount, and the plaintiff decides that they want you to pay the rest, they got to file a lawsuit, and it starts all over again. It starts all over again. Because anything you sign is, the result of that is that this case is conditionally dismissed with the one major condition out there is that you will cooperate with applying for some funds that the state will decide how much they might pay in relationship to this rental claim.
But by signing that order, I'm essentially pleading guilty to owing that much rent.
Guilt is not a concept that we use in civil proceedings, but your point is well taken. Are you giving up your rights to defend against a claim for that amount? And the answer to that is unequivocally no.
Not
absolutely not. I mean, I wouldn't even suggest that you sign something that would say that you don't have the right to, if they sue you for that amount, that you don't have the right to then go forward and
Or I sue them.
Or you sue them. Yeah, either way, there's nothing that they can sign, that they would even sign here that says specifically waiving. So for example, if you sue them, claiming an amount that you believe that they owe you, they will assert as a defense to that they believe that you owe $12,000, et cetera, dollars.
So this order will not prejudice my ability to.
Absolutely, and we can put that in the order, that this order does not prejudice your claims and defenses against
Breach of warranty and things like that.
Well, we won't put that kind of language in it, but any claims and defenses that defendant may have. Nor does it inhibit any claims and defenses that the defense may have. I mean, that's the nature of this. And your point is well taken there because that language is meaningful language to put into the document. Because the document is not intended to prejudice that. That's why it ends up being a dismissal. And this case is not a civil money case. Civil money case, if you got a judgment that says that you owe X amount of money, as a civil judgment case, that's something totally different. That means they can go after your wages, they can go after your lien on property, et cetera, et cetera, et cetera. That's not what this is. This is a dismissal that has conditions to it. One is that you will move from the property on before April 1st. Two, that you will participate with the CR program in an effort for the plaintiff to collect some portion of what they believe is owed. And it also provide that you maintain your right to bring any defenses and any claims and defenses that you believe that you might be entitled to bring. I couldn't stop that anyway, because this is just a landlord-tenant case. And once the parties agree to some type of move out, then that ends the landlord-tenant part. The money part, none of this ends the money part. If both of you agree to walk away and say, let's dismiss this case, I'm moving on March, I'm moving on April 1st, I'm moving next week.
It's guaranteed in there. Oh, excuse me.
I'm moving April 1st. If nothing, unless the party put in the order, and I think this is kind of what you might be looking for. If the parties put in the order that this case cuts off all rights and claims that any party will have against the other party, then you could do it that way. That's not in this order.
It's very general. It's very general.
No, general is better for you. Yeah. General is better for you, because if you don't explicitly exclude your rights and your defenses, then they're not excluded. So most of these orders will be general, but it is meaningful to put in language that the parties reserve their rights to claims and defenses that they may wish to assert. That language adds an additional layer of protection, but without you saying something specific, there's no way you waive your rights without saying something specific. The way that works is you retain those rights unless you specifically waive them. And this is a landlord-tenant case. If it was a civil judgment case, then you gotta be a little bit more specific about that, because a civil judgment case means that if an order is entered, that order says that there is a judgment entered against you for X amount of dollars. And there's nothing here, nothing even close in this case. That's why the language is general, right? General, you have to specifically give something up in order for it to be given up. All right. So I think that with the additional language that the parties reserve their right to bring claims and defenses, and that none of those things are defeated by this order, that they are preserved, and that this order does not prejudice or defeat any of those rights and claims that the parties may wish to bring. I think that that will tighten this order up and do what it needs to do. As it relates to your part on the other case, I do need that case number cited in this order so that I can make sure that I track that case and have that case closed out so that you don't get the stuff that you've been getting on that other case. That's a part of the agreement. You got to go along with that other part as far as the CR part, put it in the application. Let them decide what that is, and if the plaintiff decides that they want to go after you for something more than that, then you still have your rights, your defenses, everything that you want to raise.
So, Your Honor, is there a way we can withhold the final decision until I actually see the order? And
well, given, of course you can, but not today. Today, what you do is you make a decision, and I'm not going to sign the order unless it has the language that we just talked about, that your rights are preserved, that you can bring any claim that you believe that you have the right to bring, you have the right to any defenses, that no money judgment is entered against you, and that you are not stipulating to the amount set forth in the document.
with regard to that, because that's the area I'm a little concerned about, is when she puts forth the idea that I have to participate in the CR program. Obviously, what you said, there's going to be a balance there. I know the governor said there's a certain way that balances can be addressed. And is there a way that even that balance can be negotiated per what the 12-month period I think the governor said, or?
Absolutely. That's something that you all were talking about along the way. What you have to do is you have to participate in good faith with the CR program.
Understood.
And I'm sure as a part of that, you can tell CR that you don't believe that you owe that much. But what you can't do is you can't go in there and say, I don't want to pay them anything. Let them decide that. And if there comes a place where there is some issue about whether or not you have to pay or owe a certain amount and so on and so forth, and they want to sue you for that, then they have to bring an action to sue you for that.
I can file a counterclaim.
You can file a counterclaim, or you can file your own action, and they file a counterclaim. All of that is open. Those things are not resolved in the landlord tenant case. That's why when the best thing that the parties did in this case was to give an adequate opening statement, because when Ms. Cohen gave her opening statement, you gave your opening statement, because I'm a judge and I served on many dockets in this court. I know what applies in a landlord tenant case and what applies in a civil case. In this case, the landlord tenant case is a narrowly drawn case. Civil cases, a whole bunch of other stuff. Landlord tenant is a narrowly drawn case that has to do with the right to be able to stay or the right to be able to leave. Sometimes people file with that a claim for money damages, and that creates a landlord tenant case plus a civil case. This case is not a landlord tenant plus a civil case. It's just a landlord tenant case. And that's why
Limited jurisdiction.
Limited jurisdiction and limited implication. The parties can broaden that. And the way the parties can broaden that is to say, Judge, since you're a court of this jurisdiction, we stipulate to the entry of a money judgment. We agree that X amount of money is going to be paid, and I'm willing to sign off on that. Because I'm a judge of all of these dockets, I can sign that, but nobody's doing that here. All right, Ms. Cohen?
Yes.
Okay, so, Your Honor, I want to, the verbiage that I use, because I'm changing it as we speak, is that this stipulated consent order does not prejudice plaintiffs' or defendants' rights to assert future claims or defenses. Is that acceptable?
That's acceptable.
It's acceptable. I mean, yeah, he
Okay.
says that's,
Okay.
I mean,
All right, so,
yeah.
and I got the case numbers right. So I could send this right over to you, and, and perhaps Mr. Kramer could sign it, and we could, finish up this case today.
It sounds like it to me. Send the order
Okay.
over, give
All
it to Mr. Kramer. He can sit down and take a look at it. I'll go forward with my docket, and we'll come back up.
Should I send it to your email?
Yeah, send it to, you can send it to me, but also to Latifah Hunter, Latifah.Hunter, my clerk. You got that email address?
Well, every time I've been sending it to that email address, it shoots it back to me and says it's undeliverable.
Okay, well, send it to me then.
Okay, I will do that right now.
Send it to me and I'll get it to her, and then we'll run it out. Mr. Kramer.
May I ask you one more question?
Yes, sir.
So leaving out the language with regard to the CR 12-month thing, that won't be an issue?
No, that shouldn't be an issue for you. I mean, you'll negotiate in that part of it as you get to that. And
As we get to zero.
yeah, as you get to zero. And the main thing is to do it in good faith. And
Absolutely.
I suspect that both sides will work through that in good faith. That's all you have to do is deal with that in good faith. If you deal with it in good faith, and that should resolve that part. Right?
Right.
Okay. All right, so let me get a copy of it with the changes, and then you take a look at it.
Okay, it'll be there in a minute.
There was a typo in one of the paragraphs. I'm gonna just take a quick look.
Okay, yeah,
Thank
if
you,
you, yeah.
Johnny, I'll be right with you. Just a moment.
I have one question, Your Honor.
Are you on? Oh, yeah, Ms. Coleman, go ahead, ma'am. And you're waiting to talk to someone, right?
Am I able to get someone to represent me, or do I do it myself?
All right, have you spoken with a lawyer yet?
No, sir.
You're waiting for me to put you in a room, correct?
Once, can you say it again?
I'm getting ready to send you to a breakout room now, man. I told you to wait, didn't I?
Oh, I was trying to make sure, because I'm sorry. I apologize for that. Yes, I've been waiting.
I told you I'm gonna send you somewhere.
Okay, I'm sorry.
Okay, I'm sending you right now to breakout room number 2. You're gonna talk with Mr. Santorio. There you go, ma'am. Excuse me.
Thank you.
I'm gonna send you to 1. Just hold tight. 1. There you go. All right, I gotta send this. Yeah, Miss Coleman, I sent you to 2, but then I brought you back to 1. Are you able to click on to 1?
Let me check and see. Hold on 1 second.
Well, hold on a second. Here's what's gonna happen. I'm gonna send you to 2. Don't go there, okay? You're gonna see 2. Don't go there. Then I'm gonna switch you back to 1.
Okay.
So hold on now.
Okay.
Now, 1 should come up there. Now go. See it? Not yet. Ms. Coleman, you don't see the notification?
Nope, it showed me that you had moved me to break room 1 though.
Yeah, click on that one. Click that one.
But it didn't give me no option to click on it. Should I leave and try to go to the break room?
Yeah, that's what yeah. So it doesn't tell you to go to break room?
At first it gave me an option. Now, should I click out of here and then click break room number 1?
Yes, click break. Yes.
Okay.
Oh, that didn't go well. She's not there.
There was in paragraph 4, it said by and upon, so I changed paragraph 4 just to say upon. Maybe that was it.
Yeah, that's the one that I was talking about. Yeah.
Okay, so I had that change. I said, agrees to upon expiration of the CDC eviction moratorium.
Very well. So I'm awaiting your, and then I will get a copy out in just a moment. Mr. Santorio, I think I lost her. So if she calls back, get her into number 1. Something happened.
Sure.
All right, Mr. Bajani, case number 21-340077. This is Mutual Property Management LLC versus Asia Williams and other occupants of property at 16590 Warmer. The matter is before the court on the filing of a complaint for non-payment of rent. This does appear to be the first hearing regarding this matter. Your appearance at this time, Councilman.
Good afternoon, Your Honor. Lee Bajani on behalf of the plaintiff. My bar number is P74626.
Thank you, Mr. Bajani. Do I have on this Zoom Miss Asia Williams or anyone staying at the property there on Warmer Street? If you're on the Zoom, please say something. All right, it is the first hearing. It looks like the defendant did not appear regarding this matter, counsel, so I'm going to go ahead. I will set it for a subsequent hearing in this matter. I'm going to set it over for the 1st of March, 3/1/21 at 9:00 a.m. The defendant does not appear on that date. I will entertain a motion to dismiss this, strike it for entry of default on that date.
Thank you very much, Judge. Good afternoon.
Ms. Coleman, I know that I lost you. I'm glad that you're back. I'm going to send you now to breakout room 1. Let's see if we can get this right this time.
Okay.
There is your notification. All right, so Mr. Santorio, Ms. Coleman is in breakout room 1. Ms. Scott is there too, and Ms. Butler as well. Mr. Wasbury, this is case number 21-340084. This is McCoy Townhouses versus Deborah Hicks and other occupants of property at 5605 John C. Lodge. Matter is before the court for a first hearing regarding a complaint for non-payment of rent. Your appearance at this time, sir.
Hey, please the court, Mark Wasbury, P. 51575 on behalf of plaintiff.
All right, thank you, counsel. And this is the first hearing in this matter. It looks like, and let me see, do I have Ms. Hicks on the Zoom? Deborah Hicks?
Yes, yes, I'm here.
All right, and Ms. Hicks, you live on John C. Lodge, is that correct, ma'am?
That's correct.
All right, ma'am. All right, this is the first hearing in this matter, and I'm going to set it up. You have not had an opportunity, ma'am, to speak with a lawyer regarding this matter. Is that true?
That's correct.
All right. So what I'm going to do is I'm going to set it up where you can speak with a lawyer today, and I'm going to set a new date as I'm required to do by state law. And that new date is going to be the 24th of March of 2021 at 9:30 a.m. 3/24 at 9:30 a.m. That will be the next date that you will come back to into the Zoom using the same information you used today. You understand, ma'am?
I do. Thank you.
All right, so hold tight. I'm going to get you to a lawyer in just a moment that you can discuss your matter with, ma'am. Mr. Wasbury, the next date on this matter, sir.
Thank you, Judge.
Thank you, sir. Good day to you.
You too.
Hi, are you my lawyer?
No.
Okay,
I'm going to send you somewhere. Just hold on a second, okay? I'll come back to you, Ms. Hicks.
thank you.
So, Ms. Hunter, I'm sending that. All right. So, Ms. Hicks, I'm waiting for the lawyer to come back into the courtroom, and then I'll get you all set up.
Thank you. Thank you so much. No worries.
No problem. All right. Do I have Mr. Cox? Are you there somewhere? Do I have Keith Swift or Marcia Park on the Zoom? Either one of those persons? This is case number 21-340080. This is Sweet Living Incorporated versus Aaron Cox, versus Keith Swift and Marcia Parker and other occupants of property at 12627 West Outer Drive, apartment number 2. The matter is before the court on the filing of a complaint for non-payment of rent. The plaintiff's attorney is Mr. Aaron Cox, P69346. Oftentimes represented by Mr. Porca. Neither are on the Zoom at this time. It also appears that neither Mr. Swift nor Mr. Parker has appeared in this matter, or Ms. Parker, I should say. Accordingly, I'm going to set the matter over for a new hearing date as required by the administrative order. That will be the 1st of March, 2021, 9:30 a.m. Even if it does not appear, the court will enter judgment by default at that time. If plaintiff does not appear, the court will dismiss the matter at that time. So, all right, so I have a case that doesn't come up until 2:50. That involves Arlene Hernandez. Are you on the Zoom? Hernandez? Anybody living on 51st State Street? Say something if you're on the Zoom.
I think that's her, Judge. She's muted.
All right, ma'am, unmute your device. What's your name? I see you trying to talk to me, but you're not unmuted. So go ahead, take your time, see if you can find a way to come off.
Just find the microphone.
Yeah, it says that she's not, it says that she's muted.
Yeah, she is. If she could find that microphone to the bottom left, just press that. Bottom left.
All right, so keep working at it, ma'am, and see if you can find your way through. I'll come back to your matter in a moment. Mr. Centurial, Ms. Deborah Hicks wishes to speak with someone. She has.
Got it.
All right, I'll be right. No problem. Be right with you. She has the suffix 0084 McCoy Townhouses versus Deborah Hicks. Mr. Wasbury, Attorney Wasbury, represents the plaintiff. He was just on. I set a new date for the 24th of March at 9:30 a.m. and Ms. Deborah Hicks wishes to speak to someone. It is a non-payment action.
And it's March 24th at what time, Your Honor?
9:30, sir.
9:30. Okay, if you can give us another breakout room because we're having some trouble with Ms. Coleman's.
All right, I'm putting you in breakout room number 2, and Ms. Deborah Hicks, Ms. Hicks, you're going to breakout room number 2 as well. You're still there, aren't you?
Yes, I am. Thank you.
There's your notification, ma'am. And maybe I'll switch Carla Butler out of there. And so, man, your name is, are you Eileen Hernandez? Is that correct?
Yes. Yes, I am,
All right.
Arlene Hernandez.
You live at the property on 51st Street, is that true?
Yes.
Okay.
36.
Yeah, this is case number 21340092. This is Muriel Suarez versus Eileen Hernandez and other occupants of property located at 4336 51st Street in the city of Detroit. The matter is before the court on the filing of a complaint to recover possession of property. I know that Mr. Justin Smith represents the plaintiff in this matter. And I called the case a little bit earlier. I also see that Mr. Suarez is also on the Zoom. And so, ma'am, Ms. Hernandez, you've already indicated your presence in this matter. And Mr. Suarez, state your name for the record, sir. Yes, sir. Your name for the record, sir.
Mauro Juarez.
All right, thank you, Mr. Juarez. I'm going to wait a few minutes for Mr. Smith to maybe zoom in, but I'm already on the record in your case. I am going to give Ms. Hernandez an opportunity to speak with a lawyer. I'm going to give you someone that you can speak to regarding your legal rights. You have the right to the assistance of a lawyer, and that someone that may be able to give you some information regarding how you may be able to go forward in this case. And then I'm going to set a new date on this. That new date is going to be the 2nd of March, 2021. And that's going to be at 9:30 a.m., March 2nd, 9:30 a.m. And we're waiting for Mr. Smith to come. And I'll go over that information. Ms. Coleman, were you able to speak with someone, ma'am? She's gone.
I'm here.
Ms. Coleman, you still there?
I'm here,
Not-
Mrs.
No, she's not.
All right. Ms. Scott, did you want to go into breakout room number 2?
I can, yes, sure.
I'm good.
Ms. Coleman,
You're
you're
good?
good.
All right. Or I could get you started with Miss Hernandez.
Okay, I can do that.
Okay, Miss Hernandez, I'm going to send you to breakout room number 1, and you're gonna speak with Miss Scott.
Okay, how do I do that, Judge? I just go over or press a button?
You're gonna get a notification from me right now. See it? There it is.
Okay, yeah, and then it says join.
Yep. All right, and Mrs. Suarez, we're waiting on Mr. Smith, and let's see if he comes in. If not, you'll have the new date, and then you can inform him of the next time to come back. Okay, but just hold tight for now.
Okay.
Judge, I'm gonna take 1 minute.
Go ahead now. Mr. Smith, on the suffix 0092, Mario Suarez versus Eileen Hernandez. I've called that matter, and Mr. Suarez is on the Zoom, as well as Ms. Hernandez. Your appearance, sir.
Thank you, Your Honor. It's Justin Smith. I represent Mr. Juarez. My P number is 51886. I apologize to the court for checking in just a little bit late.
No problem, sir. What I've done is, it is the first hearing regarding this matter, and I've set up for Ms. Juarez, sorry, Ms. Hernandez to talk with a lawyer in a breakout room, and I've given a new date of March the 2nd, 2021. We've been giving dates a little farther out than that because of EDP or CR types consideration. I noted that this was a termination action. Is your client interested in CR or EDP type funds in this matter, sir?
I usually encourage such things, Your Honor. I confess that I haven't spoken to my client very recently, but perhaps if we have a breakout room, maybe we can discuss things as we might. I acknowledge this is the first hearing March 2nd, so this is the first hearing, and March 2nd would be a regularly scheduled adjourn date anyways. So I'd like to talk to my client if I could in a breakout room, maybe with the tenant.
All right. So the tenant is talking with Mr. Santorio right now. So I'm going to send you with Mr. Suarez, and then as soon as the tenant is back, I'll set up a way so that you guys can talk as well. So Mr. Suarez,
Very good. Thank you.
I'm going to send you, Mr. Suarez, to a breakout room number 3, and you're going to meet with your attorney there in breakout room number 3. Mr. Smith is going there, and Mr. Suarez.
Thank you.
And Mr. Santorio, in that case with Ms. Hernandez, the plaintiff does indicate that they would be interested in CR type consideration, even though it's a termination action. And so he's talking with his client now to make sure that his client is interested in doing the same. He also indicated that he might be interested in talking with Ms. Hernandez. She's probably not going to be returning into the courtroom.
Oh, did she? Okay, I was going to say when I popped back in there. I was just speaking with Miss Hicks.
Yes. So, Miss Scott is speaking with Miss Hernandez in number 1. So, can I send you to number 1 now?
Sure, I can go to number 1. So there's all right. So there's a Miss Hernandez.
Yes, and Mr. Justin Smith is the counsel on that matter for the plaintiff, and that's case ending in 0092. And Miss Scott already began the intake with her.
Miss Scott. Okay, and when is this has this already been adjourned?
Yes, I set it for the 2nd of March because of the nature of the termination. So when he comes back in, Mr. Smith, from talking with his client, he wants to make sure that his client may very well be interested in the EDP. And if that's the case, I probably need to move that date further into March.
Yeah, I would appreciate, if we're going to do the Sarah program, I would appreciate that. It'll give us more time. We're still waiting on them to finalize the plans.
So make sure, as I send you into 1, make sure that everybody comes back in the courtroom, so in case I have to adjust that date.
Okay. Thank you, Your Honor.
Right. Thank you. So, Ms. Finch, did you see the article?
From the news, Judge?
Yeah.
Yeah,
Collision with a emergency responder vehicle.
yeah. That's just so unreal. He has a sister, right? Yes.
All right, while I'm waiting, anything on, let's see, Ashley versus Kramer? You can come up to the podium, sir. And Ms. Cohen is yet on the Zoom. All right. And both sides have had an opportunity to read through the order. I did receive it on my phone with the updates on my device. And it looks like it comports with what the objectives are here. And Mr. Kramer, well, I'll come to you in just a moment. Mr. Smith and Mrs. Suarez back. And Mr. Hernandez is speaking with someone in the breakout room. And I did speak with Mr. Santorio, and he says that if there's going to be EDP considerations, then having a date a little further in March is very helpful. That is, I said it on my typical date, if there's going to be zero considerations would be March 24, because that's about when we know that that program is going to kick in, and we'll know what the dynamics are.
Yeah, Your Honor, thank you for this. And I did have a opportunity to speak with my client. Truly, this is a situation, I must say, where my client's looking to actually move into the subject premises. It's not a situation really of money. So from that standpoint, I think that if we could get the soonest possible next hearing date, I think that would be very helpful. Now, my client is a pretty pragmatic person as well, and they might listen to the hope that some money might come through, but right now it's not like a situation where they're just looking for money. Really, they would like to occupy. My client would.
All right, very well. I'll communicate that to Mr. Santorio. And what I'm going to do is I'll leave the date on March the 2nd. That's the earliest date that I have available. And by that time, we'll have some information. And then by that time, we can drill down on the issue of perhaps a move-out date if there's not a willingness to consider other options. Because this is the first hearing, I have to give it a second hearing date before we can make any progress on where we go from here.
Thank you, Your Honor. We'll take the second. Do you have a time, or will we just be noticed?
Yeah, that's at 9:30 a.m. And Mr. Santorio is back in the courtroom. And I know that a decision has not been made as to whether or not they will represent the person. But there is an indication that Mr. Suarez, who is the owner of this property, may very well want to take possession. His objective is to get possession of the premises. Although he's not ruled out the possibility of some financial remunerations, his number one objective, according to Mr. Smith, is that he wants to get the property back. So I'm leaving it on the 2nd of March at 9:30 a.m. with those kinds of issues in mind.
Thank you, Your Honor. I do look forward to brother counsel perhaps contacting me with some options, because this is a little bit up in the air, but I appreciate the court's consideration for the earlier date of March 2nd.
Yes, sir. All right. I wish you well. All right. Good day.
Thank you, everyone.
So we have the one more with Mr. Cox, but he's not. It's just a few minutes after the time that was supposed to be. So I'll come back to that in just a moment. All right. I'm back on the Ashley Master versus Kramer regarding the case with the suffix 6587, and there is another case that is attached to that case. All right, and Ms. Cohen is on the Zoom, and Mr. Kramer is in the court. Mr. Kramer, you had a chance to review the document, sir?
Yes, I did, Your Honor. I
You
have
keep your voice up if you will.
Yes, Your Honor. I did read it. It seems okay. There are 3 questions that I have that concern me. First off, I've never actually seen the ledger. And by my math, and granted I went to public school, but it was a very good one.
I went to public school too. I don't know what you're talking about. Just hold that back.
And we seem to be about 3 $380 off there, which I can't explain because my math is, but the actual months that are in question here don't add up to these figures.
All right. Well, before the question on that, that is a consideration that is not something to be addressed here because you don't agree with the numbers anyway. You agree that there may very well be some rental for purposes of the CR program. But you don't agree with the numbers, so we don't have to address that. If they sue you, then you'll have to address that. And all of what I'm saying is being recorded. There's a court report taking this information down. So you can rely on that. If they sue you, then that issue will come up then. It doesn't come up now.
That's all said. The second one is the language sounds really good, but I guess my concern, and forgive me if I sound naive here, but I understand that we are going to find a way to deal with that first judgment or eviction. My concern is that, in the real world, like if I move out before the 31st, they are going to run like an RPOA or in a credit check. How will this balance show up in any kind of review?
It doesn't, because this is a conditional dismissal type situation. So this is like the case is dismissed, but this is held in abeyance.
Right.
And as long as everybody do the part that they're supposed to do, this does not back up into the case. It shows a case dismissed. If for some reason you don't move out by that date, right, or you don't participate in CR, then the plaintiff can file a motion for the court to reopen the case. Otherwise, case dismissal. None of this shows up on the readout. What will show up is the action that this court will take pursuant to this order.
I don't follow.
But what will show up is the change in the adjustment on the other case that will lift that off of showing up as something as a hit against you. That's the only thing from a court documentation standpoint that someone could look up. They will see that case was adjusted in light of an agreement.
Given my experience already, and Ms. Cohn's aware of this, that I was looking quite some time ago, even before we went into a holdover situation, but because of this thing being on my record, I think landlords have this understanding that they talk to each other. Can we have some sort of agreement put into the record that nothing derogatory can be, essentially, because essentially I could be out and then I'll be out on the street literally.
Well, if they ask for a recommendation, I suppose the plaintiff would give a neutral recommendation. Madam Counsel.
Are you asking me a question?
Oh, yeah. Mr. Kramer brought up if someone writes or requests a referral or recommendation from the plaintiff Ashley Master, is it agreed that any indication would be neutral?
Well, yeah, we, as I'll state on the record, Your Honor, we don't give any information except their rental amount and when they rented there. And the only information that we could release would be a ledger, but we would have to have the authorization of Mr. Kramer. So if Mr. Kramer doesn't want to give us authorization to release any information, then nothing would be released. But the only information that my client provides is that they rented there from a certain amount of time to a certain amount of time, and what the rental rate was, and we will give a ledger to Mr. Kramer to provide to them. I mean, that's the only, that would be the only thing we would do.
So your agency would agree not to send a ledger to the to anybody requesting it, except to Mr. Kramer?
Except if Mr. Kramer gives us a release to do that. We can't give any information out without a release by Mr. Kramer. Authorization.
But will that in and of itself, if I don't give that authorization, will that also actually essentially tank this agreement? Because they may want to know, for example, while we're operating in good faith here and we're looking at CIRA to address the balances and whatever's left over I can address, how is that going to be addressed sort of in the real world of a landlord, a future landlord saying, what is the balance that does Mr. Kramer have an outstanding balance?
Right. And that's an important consideration. That's why I would suggest that there be, that if something is requested, that whatever is requested would, we limit what that is right now. If someone has, if he gives a clearance, then the only information that can be provided is that he rented there, the period of time that he rented, and how much the rent was. No ledgers. Would your client be willing to agree to the same?
My client will agree to not give out any information without the authorization of Mr. Kramer. We don't fill out a landlord reference unless Mr. Kramer signs an authorization.
And here's what he's concerned about.
Okay, well, then he has to sign the authorization. That would be the only way that they would get information is from him. And if he tells us to do this, if he doesn't, I don't know how it works. If you go and you apply for an apartment and they're not willing to, they say, well, we need an authorization or we need a ledger. I can't control what information another landlord's going to ask for.
Absolutely.
I can tell you that I'm not going to give him any information without a signed authorization from Mr. Kramer.
Right. And of course, the issue here for Mr. Kramer, it seems, is that if he signs an authorization, he does not want issues that are disputed between these parties to become a part of any release. That's the issue. So, and that makes sense in light of how we're trying to get this resolved. So if he asks for an authorization, if he asks for release, the only thing I suppose that if there's going to be a compliance with this order, the only thing that could be released is that, yes, you rented here before from this date to that date. That's all the information. That's all the information available at this time. So I think the order might, if we can get that language in the order, it simply says that if Mr. Kramer authorizes a release of information, the only information will be released is that he rented from the period of rental, and that he no longer rents from the property.
Your Honor, and I know this because I've actually looked at 20-some properties and 60 to 80 apartments in the last year. And this is a question that's regularly run into.
I know it is too. Yeah.
And so is there a language that could reflect that with regard to what you refer to as the ledger, that all balances have been addressed like per this order?
You don't want to get into those kind of weeds. You can't. There's no agency that's going to be able to get it, and would never be able to get any language that does that. What you can do is, this is what I'm suggesting you put in the order, that any recommendation or any referral be addressed in a neutral way. That defendant rent was X amount a month, rented from this period to that period. There's no further information about this rental.
He's left with no outstanding issues, or I don't know if I can legally say that.
That's what a neutral recommendation doesn't do that. The two of you on both sides have some challenges that you may assert in the future. So the recommendation, the best case scenario is for the recommendation to be neutral. You rent it from X period, the rental amount was X amount, and there's no further information available.
But if I don't give permission to release those ledgers, I'm not going to find a new apartment.
Well, whatever you give them permission to release.
But then if I release that and it shows the balance that we're working on.
Listen to me very, very carefully. As it relates to this rental, if this language is in the order, no matter what you sign for them to release ledgers or whatever, they are not going to release anything but a statement that says you rented from X period to X period, that your rent was X amount per month. No further information about this rental. That's all they're going to release.
There won't be a judgment history on this.
No, that's all.
So that's where that might work together.
That's where that's what's called a neutral response to a release. It's neutral.
Okay, so I guess that and given that we are separating here by March 31st at the latest, there is a 1 month rent deposit there. Can that be applied to the balance immediately as opposed to like sitting there for 30 or 60 days?
If you stipulate to that being applied, then
They can do an inspection and then make sure that
I'm having a hard time hearing. What is Mr. Kramer asking?
what he's asking, he says that he gave a deposit at the time that he moved in, and he says that he would like it stipulated that that deposit goes towards any balance.
I can't do that. I mean, under the Michigan Security Deposit Act, within 30 days of him moving out by law, we have to apply it to rent owed. But the law says what it says under the Michigan Security Deposit Act. And I have 30 days to deal with that security deposit.
Absolutely, and you also, by stipulation of parties, can waive the same. But if you're not willing to waive that, that makes sense too. That's not something that should affect.
I don't feel comfortable. I mean, the law says what it says under the Michigan Security Deposit Act, and I absolutely will follow the law. With regard to the last request,
Let me stop you. I would never suggest that you not follow the law. Of course, you know that. What I'm saying to you is that parties can, by stipulation, agree to waive certain provisions and embrace a pathway forward. And I don't suggest that you do that in this moment either, but they can do that. That's not working in violation of the law. That is the parties stipulating to a pathway forward. I don't recommend that either. Mr. Kramer brought it up, and so I raised it too. But I don't recommend that you put that in this particular document, and that there is a duty to inform you within 30 days about issues and so on and so forth. And that's something that has nothing to do with this. Sometimes people make it a part of this, but you got enough going on here. I suggested that not be a part of this. And there's no way I can force the parties to make that a part, because under the law, it's something that happens after the tenant moves out. The parties sometimes can agree, but I can't say you got to do this because that is something parties would have to stipulate on.
Your Honor, the only reason I bring it up is because the landlord's management team has regularly not showed up. At times, they've scheduled inspections for 3 days. They don't show up. We've had a heat issue in the building. They don't fix it. It's been a year.
And to the extent that something like that occurs regarding the security deposit issue, there's a duty that says that if they don't comply with the Security Deposit Act, they can end up owing you triple the amount of the security deposit. So that's the way that works. If what you say is true, then if they follow that practice with this, then shame on them. They lose money. And that's now you understanding some of the reasons why I say that's an issue. You don't need to put that in this.
Okay.
That does nothing for this document. Okay. This document takes care of some other issues, but that issue, it may be some things that work to your advantage, to their advantage, or it may work out properly like it's supposed to. And if it doesn't work out properly, then there are consequences to that. That's why that law is separate from the case itself.
Understood. Okay. Other than that, I'm fine.
Okay.
All right.
Your Honor, I added the sentence, if a landlord reference is requested and the defendant authorizes plaintiff to release information, the only information that will be released are the dates of rental and amount of rental.
An amount of rent. And the amount of rent.
I guess it would be the dates of rental and the rental amount.
Yes. That's all that would.
So together with no action or judgment, that should be enough for the new.
That should be enough, and it's a neutral recommendation. If that's given what both sides are dealing with, that's the best that you can hope for is a neutral recommendation. That way, nobody is putting something out there one way or the other that's derogatory or exaggerating or anything else. It's just rent it. This is how much his rent was. No further information. Now, all right.
Yes.
So we'll make that adjustment, and I'll sign the order. You go ahead and put that language in. I'm going to.
Okay, I already did. I'm going to email that to you right now.
Right, and Mr. Kramer, I'm going to print it out, and with that, you should put your signature to it, Ms. Cohen's signature. I'll sign it, and then I'll follow up with the other case. You got the other case number, correct?
Yeah, I do have both of them off the top of my head. There's 2034.
That's all right. I'm talking about, it's in that written document, right?
7. Yes, they're both here.
Okay, so I'll follow up on that other case to make sure that that case gets flagged in light of this settlement and this resolution, right?
Right.
And then you should be good to go forward. So I just received it from Ms. Cohen. I'm sending it to Ms. Latifah, Ms. Hunter, because we have some problem going on with that. And then she's gonna print it out and give you a copy right now. So look at it and sign off.
Your Honor, just one more thing, if I may.
Yeah.
And I'm not questioning it. It's the Sarah situation, because I understand that's a very fluid situation.
Yeah.
Is there any consideration we should give to like what time I have to be initiating this stuff, or is there a way to sort of have a proper notification or something?
Well, the thing is that the Sarah program is not up and running. So I think that, what you want to do is you want to follow up on that sometime during the month of March, because that's when that program is supposed to open up.
And then coordinate with her.
And then coordinate with Ms. Coleman.
Yeah, Your Honor, I will make sure when that Sarah program becomes available, because I'm watching it on a daily basis, that the application gets printed out, put it in an envelope, and put on Mr. Kramer's door.
Okay. All right, makes sense. Okay, good enough. So I've sent it to Ms. Hunter. Ms. Hunter, you'll need to pull that order and copy it, and then you'll get a copy in just a moment, and I'll sign off shortly.
Thank you.
Okay. Thank you, sir.
Thank you, Ms. Hunter.
Do I have Mr. Bernard Goss on this Zoom? This is case number 21340-095. This is Sweet Living Incorporated versus Bernard Goss and other occupants of property at 12851 Lasser, apartment number 6. The matter is before the court on the first date of hearing regarding a complaint for non-payment of rent. It looks like the attorney of record in this matter, Mr. Aaron Cox, or Mr. Horvath, are not here. The defendant has also not appeared regarding this matter. At this time, I'm going to set the matter on for a subsequent hearing date. As just said, the first hearing that date is going to be 3/2/21, and that's going to be at 9:45 a.m. If the defendant doesn't appear forward an adjustment by default, if the defendant appears in court, the court will give further consideration. If plaintiff counsel doesn't appear, the court will dismiss the matter. Did you get that copy yet, Ms. Hunter? Just send it to you.
Okay.
Okay, make sure Mr. Kramer gets a copy.
Okay.
So, yeah, then give that to Mr. Kramer.
Want to look at it first?
Yeah, he needs to sign off on it. I'm ready to sign. Ms. Cohen is in agreement with the same. My wife ain't gonna let me get no puppy that big. My officer is starting, he's getting a new puppy and just one more left in the litter. I show my wife the size of the puppy. She's looking at me like, oh,
I'm just
the size of it now, and then Rolls.
What are you saying? Instead of bringing back one, I'll bring back two.
Yeah.
That way you have a companion that matches you.
Yeah.
You signed it?
No, not yet, I just have one question. If it's okay.
Step up.
Mr. Kramer? Yes,
I
sir.
don't want to be annoying to you, Your Honor, I just have one more question.
Yeah, go ahead.
With regard to the outstanding balance, how will that show up in any kind of search? Will it show up as a pending?
You've asked me that before. The case will be dismissed. The case will show up as dismissed.
Okay.
And the only way that comes back is if there is not compliance, and then somebody files to reinstate because of lack of compliance.
Okay.
Yeah, you can do that.
Yeah, these are.
Did she just correct that?
She got the 7.
What is it?
She put the 7 instead of 8 on there.
For the date.
Oh, no, that's okay. That doesn't matter. It has the.
Okay, just wanted to make sure.
I'm going to sign off on it, and the order is going to be dated today.
Okay.
Mr. Kramer has signed, Ms. Cohen, and I see that you've indicated the approval with your signature in printed form. I am signing the order at this time, and I'm dating it for today's date, the 8th of February, 2021. And my clerk will make sure that everyone has a copy of the document, copy of the order in just a moment. Mr. Kramer, I will follow up with with that part regarding the previous case, and I'll make sure that gets taken care of. And if you, don't just call it amnesia or anything, but if there's a problem with that, that you would discover with that other case or whatever, I'll call and I'll follow up on it again. I should be able to get that straight, and we shouldn't have a problem.
Thank you, Your
If there's an issue, then call and just give the clerk some information, and I'll follow up. Well, I wish you well. I think it's the most reasonable way to resolve a case, given the challenges that were a part of this whole thing. And I wish both sides well.
I think without COVID, this doesn't happen.
I'm sorry.
Without COVID, none of this really happens.
Yeah, I mean, that's without code, I would be looking into this machine right now. But there are some efficiencies that have been learned from this. So I think that even when the court is backed up, that there's still going to be a percentage, probably a considerable percentage of cases that are heard by way of Zoom, because it's convenient for lawyers, for litigants. And our court is one of those that doesn't have a parking lot. So every time you come down here, you have to deal with some type of parking situation. So, and we didn't need to have that many people in this building. I'll be glad to see COVID get knocked down. But Ms. Cohen knows, because she was getting out of here. On any given day, you never know how many people would be in this building. And you step into a courtroom. It's good we didn't have to discover COVID here at 36.
Because it's a germ factory.
The crowding of people into this building could have been disastrous. All right, so I wish you well. Ms. Cohen, they will send Mr. Kramer is getting a copy right now, a signed copy by the court.
So you don't, Your Honor, you don't want me to file the satisfaction of judgment? You're just going to do something different?
Why don't you do that, if you will? Would you do that?
I'll
And
file
then
satisfaction judgment.
I'll follow up as well. All right?
Okay.
Thank
you. Thank you, Your Honor.
All right, thank you. I wish you well, sir. All right.
Thank you. Happy New Year.
Thank you, Ms. Cohen. I appreciate you.
Thank you.
And Mr. Centurion, I think that we are all set.
Okay. Thank you, Your Honor.
Yeah.
You have a good day.
All right.
Was
you
it?
have a good-
That was an interesting day. Thank you.
Take care. Take this, Scott. Good day to you, ma'am. Deborah, you good there? Ms. Finch? So you saw as a collision with a emergency responder, huh? Oh, you're on silent. Why am I not hearing? Can you unmute yourself?
Sorry. I saw a police car and it was on channel 2.
Oh, you saw it on the channel.
Yeah, it was a police car. Terrible.
Yeah. Did you see his car was how bad? It was.
I didn't see his. No, I didn't see his car. I want to check out the news this evening, but no, I didn't see his car. Now, Michelle, Michelle Judge, the court reporter you like, the quiet one. Michelle. Yeah. She saw it on channel 7. So I'm gonna try and catch it today. It's just so unbelievable.
What you say?
Did they ever say how it happened?
Yeah, a car accident.
Chase.
Emergency responder, a police car. Said they had signals and oscillating lights on and stuff about 1 a.m. this morning.
Oh, wow.
And a collision.
1 o'clock in the morning last night.
Right, like I said, we just don't know when we hear it.
You see what I'm saying?
Yeah, just think about things. And I know that nobody could ever think of that could happen.
You know?
Not in a million years.
You gotta live life to the fullest and stay at peace with everybody you can be at peace with, etc.
I mean, I'm just so used to reading all his posts on Facebook. You know how he has that sense of humor and.
Yeah.
Every time you see him.
Yeah. I got a lot of nice pictures of him on Facebook.
Oh yeah. Like I said, we've been friends for 31 years, like brothers.
Weird and gone and just like, why did it have to be like that?
Yeah. And then it shows, the sad thing you don't want to ever think about is it shows how dangerous cars are.
Yeah.
It shows what, Judge? What?
It shows how dangerous cars are. Really.
Oh, yeah. All right, y'all. I'm gonna go on and go.
All right, then we'll see you tomorrow.
All right, yeah, we'll see you soon. Talk to you real soon. Okay?